It's fiasco. I can hear you. Yes, I've done that. Thank you.
Já faz algum tempo que falamos da velocidade das transformações do mundo. Mas, na verdade, esperávamos que essas mudanças seguissem um ritmo imposto por nós mesmos, segundo nossas próprias necessidades. Como se as mudanças fossem previsíveis ou fáceis de assimilar. Até que o mundo parou e tivemos que ouvir as notícias e ver de frente a nossa própria vulnerabilidade. Nenhum de nós esperava experimentar uma situação como esta.
We did not
Mas aqui
expect
estamos,
to face a
imersos
situation
em
like
elas.
that.
Mas
And
será que
here we are,
conseguimos aprender alguma coisa
totally
com tudo isso?
inside this amazing situation. If being capable of learning is the best trademark we have, we had to overcome ourselves to deal with it. And it's patent now that it's what is really important to us. We understand that we are part of a major ecosystem and we depend on each other. Our challenge is to learn the new pathways of digital transformation to make the difference with innovation, empathy, and courage. It's with this spirit that the LD Soft team is here to help you to do more and more for your clients and offering means for you to have efficiency even in the most unexpected situations of remote work. New tools offer what you need to give the attention that everybody needs. So you have time to offer to your customers the excellent results that they know will receive from you. So let's keep on solid and moving forward so that we can smile and celebrate the new advancements in the challenges that we have to face. LD Soft, making the legal universe more powerful through technology.
Foi amplamente noticiado no final de 2016.
We have heard the news by the end of 2016 that the neural network of Google's translator system had developed an internal language to be a bridge between the different languages that it can translate. We can think that it is like a simple creation that doesn't have an inventive nature, but this may not be true. For instance, if the language that has been created means a mechanism alternatives that can relate lexical and grammatical structures that are radically different, substantially more efficient or more effective than the previous one, such language would be a perfect state of the art to be patented in almost all legislation. 2 years later, December 18, 2018, the Folha de São Paulo newspapers announced that the artificial intelligence was creating screenplays, painting pictures, and this new technology will allow us to have the mind at work. The mind can be artificial, and the creation of an artificial mind should be protected. Do they belong to the creator of the AI or the user that has demands and has been placing data inside of it? And of both, once they have agreed upon that. And what if they have not agreed upon anything previously? And to debate on this topic, we have gathered brilliant minds under the moderation of Cláudio Barbosa. Cláudio, you have the floor. Thank you. Good morning, everyone. Welcome to the Intellectual Property Congress of ABPI. I'm Cláudio Barbosa. I coordinate the ABPI Commission that deals with the information technology. It's a great pleasure to be here with you in the chat. I have seen that we have many friends here, and I salute you all. And I really thank you for the invitation. It is such an interesting topic, and with me we'll have Dr. Wagner Latte providing the IBPI view. Dr. Barber, Mrs. Barber, she's has the North American experience to bring to us, especially the IPLA. And the artificial intelligence, as has been shown, it is a recurring topic. I can go to the origin of it. As we are created as the image of God, this gives us already this idea that we can create. The creation will be perpetuous. So this will define what is the human being. It is a personality, a character. We have several myths, and we have been haunted by some dark visions of what would be. I like the 2001, the Odyssey in Space, and or more sensitive films like Her from 2006. This matter of intellectual property and artificial intelligence has been studied since 2009 regarding this AI, and the copyright has been studied this year, and IBPI was studying the patents related to it. I will start my presentation presenting Dr. Wagner Latte, and he is in the board of IBPI, and he has been graduated in electrical energy, electrical engineer. He has a master's degree by the Federal University, a lot of experience in signals processing, especially codification. He entered in 2006 in the IBPI as a patent examiner in communications. He has been working 5 years as a technical director for patents, and today he is the general coordinator for patents, coordinating the patent examinations, the civil and electrical engineer areas, electric, electronic, and telecommunications as well. Mr. Wagner, I would like to give you the floor now. Thank you. Good morning, everyone. I would like to thank the ABPI invitation to be here representing the INPI, our institute, and where I currently work. And also, I'd like to thank the participants that chose to follow this panel and not the plenary. Unfortunately, we're not able to follow both at the same time, I think. So let's move on. The topic that brings us here to this ABPI, the role of the intellectual property here. And I'd like to focus on that and the artificial intelligence. So my intent, let's see, how can I show my slides? I have to go back a little bit. There we are. So the online tools, they bring us a lot of challenges. We are used to face-to-face, and let's move on. What I intend to cover here is to make this overview on the new trends for the application or filing of applications in Brazil, and also bring some implications that this filing of applications related to AI bring to us, some of the challenges that are raised, and also to discuss the controversy of ownership on that. About the patent application filing related to AI, I will use AI from now on. Sometimes I use IA in Portuguese, so forgive me if I use the wrong acronym. So some statistics that I'd like to present to you here, they follow the methodology of this paper performed by the YPO. I really recommend. It's thoroughly detailed, and they present a strategy that was used to select the applications that were filed and related to AI. It's not a simple task because AI can be scattered all over different technological fields. So it's not easy to identify sometimes only by the classification. So they mix in the methodology the classification and some keywords to find the volume of applications related to AI. We have seen also another work performed by the studies and projects team in the patents board. It is a technological radar that produced the data that I'm going to present here, and some of the information that come from this technological radar. Based on the study performed by WIPO, they had made a survey that is quite interesting, examining the publication of scientific articles and patents all throughout time. And in around 2010, they reached the conclusion that they had about 8 scientific articles published for each patent. In 2016, we had a proportion of 3 scientific articles published for 1 patent. So we see this decrease, or moving from theory to application, the application of the techniques. So the beginning of the studies in artificial intelligence, they date from long before the publication of the first patents. So in this first work, they had 340,000 applications published all over the world. From then on, we have to here highlight that the main filing agents would be United States, China, and Japan, where we have the concentration of most of the patent files. And here, Brazil is in the 14th place with about 5,000 applications. So, to repeat here, the WIPO methodology we could reach these results. This would be the overview in Brazil. The chart here shows the amount of applications throughout the years while they have been filed. And also you have the patents related to AI. The line will show here the number of applications in all technological areas to compare them. As I said, we have identified 5,100 applications related to AI that were filed in the ANPI, residents and non-residents. And in this chart, we can see that as of 2009, we have an increase in the number of applications related to AI that is different, or it presents a contrast with relation to the total amount of applications. So it shows that the amount of patents related to AI is growing in a higher proportion compared to the amount of applications filed. So it reaches about 25% as of 2009 and 2010. The WIPO study also was able to show that most or more than half of the patents applied or filed, they have been published after 2013 related to AI. So we can see that in the INPI, we see the same. It reaches about 55%. Moving forward, we can see how these applications were filed regarding the origin of the applicants. We can see that United States, it's predominant, 45% of the applications, followed by Brazil, 9%, so way far from United States, and Japan as well, 9%. So we have the predominance of these applications coming from United States. And we also can see to the right in this small table, in the total of applications, we have about 30% from United States, 20% from Brazil. So we can see that when we look at AI, this difference increases drastically. So there's another piece of information that is interesting here. When we look at the global data, we see United States, Japan, and China as the actors that are concentrating this technology. But here, China is not among the main actors here. It's around the 7th position here. Why is that? Because China concentrates the applications internally. And in the WIPO paper, they highlight that only 4% of what is filed in China is filed in other offices. So this is shown here. So we don't have that much amount of applications filed from China. If we look at the trend in Brazil, we have as the main actors the North American companies like Microsoft here, leading the ranking. We have the main applicants concentrating the amount of applications, or most of them, not the majority, but most of them. You can see the research that have been developed. When we look at residents, the applications that were filed here nationally, internally, we have a chart compared to the previous one that we can see a higher growth in the applications related to AI compared to others that were regularly applied or filed. So we have about 3% here as of 2009, while the AI applications, they have 17% increase. And this is equal to 462 applications compared to the previous slide. Looking to the top 15 applicants, we have Unicamp here in Brazil. And it's interesting to highlight that most of these actors, the resident actors in Brazil, either they are universities or research institutes. This is an interesting observation that we have been seeing throughout time thanks to the NICs that have boosted this amount of applications and intellectual property.
When we look at the per technological area, how can we separate these requests per area? So the classification is not sufficient for us to separate this in detail. So WIPO uses a piece of criterion by separating inventions related to AI in 3 categories. Techniques for artificial intelligence, which are the algorithms for training, identification, and all techniques used for artificial intelligence. And the other category are functional apps. Apps where artificial intelligence is very much related to the app itself. It's part of it, like voice recognition, where there is some artificial intelligence already since its very birth. It's part of it, an integral part of it. We've seen a boom in voice recognition around the year 2000, approximately. That's when this feature was presented to the market through voice recognition and voice reproduction systems. But those were rejected by the market because it demanded too much training and error was high. So the user would just lose heart and the market was not really ready for it. So producers were too anxious in putting that in the market while the technology was still immature. 10 years later, we see that it's more mature and the acceptance, therefore, was higher. The third category are the application fields. We have different areas where artificial intelligence can be used. So we see that by enforcing this type of category and the more than 1,100 requests, applications, we see that the diameter is proportional to the number of applications filed. And the most interesting feature, something which is quite predictable, is to see that most of applications is here in the fields for use or area of use. This would be an opportunity for Brazil, in my opinion. We might use methods that are known for artificial intelligence in new apps, in new uses. I think this is quite a good opportunity for companies who wish to increase their productivity. If we look at this type of classification, we see that just as WIPO has put it, we see a predominance of some areas, so to speak. Vision, this is something which has demanded many applications followed by control methods and voice and natural language recognition or processing. Whereas in use fields, transportation, medical sciences, and telecom have had a priority in the number of applications filed. for patents related to AI. So let's have a look now. Just leaving the idea, the landscape of different applications, looking at our homework. What I did was to verify for these more than 1,100 applications at what stage they are. So we see that 45% of these applications have been filed. They were filed because the applicant did not show interest for that application any longer. So that's probably because more recent technologies were found. It is known that we are examining patents that we wish we would not examine. They are old applications, old patents. We'd like to analyze new ones, but this is a historical consequence of our backlog. So we have 44% of applications awaiting examination, and 11% have been decided. So on the right, 68% were accepted or granted. I think this proportion is quite reasonable. It is compatible to that of other intellectual property offices. So when we look at the distribution of applications per year of application, we see there is a hill going up, and we need to go up this hill, and we've been making quite an effort to do this and to overcome this obstacle. I'll be very candid with you. The program for tackling the backlog has required quite an effort from our examiners, and they've shown the effort has paid off. The biggest issue related to AI, and when I say issues, are issues for the examination itself. So situations which might not have been predicted before. Some are still to come. Amongst those is the issue of ownership. Related to technical examination, what are the main challenges and implications? Well, first of all, we need to make a difference here. When we talk about inventions that use artificial intelligence to achieve a result, and those that use AI to generate new inventions. So we should separate those two. They are two different visions. Today, the problem related to technical examination is related to inventions that are AI-assisted inventions. We have not yet achieved the point where we have AI-generated inventions. So we need to predict and foresee the situation, but this is not yet part of our routine. In our day-to-day activity, we're always keeping an eye on the past and an eye on the future. So, in terms of inventions that are AI-assisted inventions, they fit the category of those that are implemented by computers. Recently, we have reviewed this under a public consultation, and by having given several talks around, I have seen there is much lack of knowledge regarding protection of algorithms for patents related to computer systems that are not the computer system itself. In other words, we still live the culture of perhaps the previous intellectual property law, whereby inventions implemented by computers were not patented or patentable. So we need to have that clear in mind. This has changed. What we try to show now is the procedure we apply and use in our day-to-day examination work. We need to be to streamline our decisions. Although we have some patents related to AI, we still have some issues that we need to add to our guidelines. We've been working with the BRICS precisely trying to address this issue. And amongst those, we would emphasize eligibility, that is the frontier of mathematical methods, Article 10, and descriptive sufficiency when we don't know how AI reaches that result. Neural networks, we would need to see the weights, how and what the architecture is for the network so that it reaches that point after training. These are some of the issues we need to standardize and clarify. And also regarding inventive activities. When artificial intelligence encompasses different topics, we need to have a technician an examiner that knows about different technological areas, and that demands training and perhaps shared examination. Now, talking about inventions that are AI generated inventions, I'd like to show to you a specific case. Barbara, I believe, will address this in depth later. A famous case study is the Debus case study, which led to a decision by the United States. That was filed by EPO and USPTO, and the inventor describes a system which was an invention that was autonomously generated by artificial intelligence. I think that was a provocation by the applicant of this patent, trying to touch on this topic. The decision, or rather our law, is quite similar to that of EPO. And I think we should assume that had this application be filed with our office, what would have been the decision? Well, on a study, they concluded here that the inventor should have been a natural person, that is, an individual, for the application to be required. So this was a requirement, at least to be part of the application. We're not talking about the content, but rather the requirement. If we look at our own legislation here, what would have been our decision? This is still my opinion, my personal opinion. This is not an official decision of the Institute, but I do believe this is probably the trend. If we look at Article 6, I have here a few parts of the article, and it attributes to artificial intelligence rights which have not yet been established. That is, artificial intelligence doesn't have its own legal feature so as to have these rights. We see that on the first paragraph, we see that the right should be assured to this artificial intelligence. I mean, how can that be? If we look at paragraph 2, the second paragraph, we see a work contract or service rendering contract. How can artificial intelligence sign a work contract? And then on the third paragraph, it's even more evident that the law was talking about individuals when it talks that the invention can be done by one or more individuals. persons. And then the inventor shall be named. I mean, although artificial intelligence does have a name, can we call it a real name, an actual name? So what I conclude from here is that our legislation also assumes here that the inventor would have to be an individual, a person. So I believe that the Davos case would also have been rejected by the ANPI had it been filed in such a way. That's a challenge then. If AI was not considered an inventor, would this have been filed as such? So this is an issue I would like to, a question mark I would like to put on the table so that we can continue our discussion. I would like to thank you all for the opportunity. I'm checking here for time so as to leave you some time for the following speakers. And I'd like to give the floor now to Claudio so we can continue. Thank you. Wagner, excellent presentation. We've had some issues here that I would like to leave till the end. And in the starting of my presentation, I think the Portuguese area of the website was not broadcasting. So Mr. Wagner's presentation, unfortunately, was not being broadcasted because for some reason the Portuguese was mute. He's a master in electrical engineer and has been as technical assistant of the Directorate of Patents as Director of Patents 3, Electrical, Electronics, and Telecom. Mr. Wagner just presented here, and it was an excellent presentation. Thank you. Now, continuing, I'd like to present to you Edson Souza, graduated in law and an expert by Fiocruz, a master's degree in bioethics by the Sheffield University in the UK, and has an MBA in entrepreneurship by FGV São Paulo, 20 years in intellectual property, and working now with Bayer Brazil. Edson, you have the floor. Thank you. Thank you, Claudio. Good morning, everyone. I would like to thank ABPI for the invitation and my colleagues from the panel for the participation. I will try and be short in my presentation. I can't pass my slides here. Can somebody help me? Okay, now it's working. Very rapidly, according to the agenda, I'd like to talk about artificial intelligence, the whole scope, and then briefly talk about digital tools, including artificial intelligence, how that has changed our research and development at Bayer, be it in agriculture or human medicine. Then I will be talking about the specific topic of our panel on patent legislation and AI implications, and then I will reflect upon the future.
I think I have a problem here. I cannot show my slides. I would like to ask for some technical support. Thank you. could we move to the next slide, please? So we have to close and open again. No problem. No problem at all. And you have your time. Yeah, it is a bit heavy. Maybe that's why. Well, let's talk a little bit about the definition, the scope. Can we move to the next slide? Thank you. A lot has been said about this topic, but I believe that there is still a mistaken understanding of what artificial intelligence really means and what it encompasses. Maybe we have a lot of sensationalism related to some science fiction movies like the Terminators, Matrix, and other movies. Besides that, we tend to give some human characteristics, features to technology, and it can lead to the belief that technology can do much more than it indeed can do at that point of time. This terminology, artificial intelligence, was created in 1955 by McCarthy, and a North American scientist, and there are several definitions on this phrase. And the simpler and that is really easy to understand would be that the artificial intelligence is an area of study that could provide or is focused on solving problems that previously were meant to be solved by the human mind. With this definition, we can realize that what we indeed have would be a series of applications that use advanced technology to provide a similar reasoning, similar to the human reasoning, to a certain end. And among the technologies that use artificial intelligence, I can mention two here, would be the machine learning, that where you provide information that will go in and out, and you need a standard or a pattern, and why you need that pattern. And a deep learning would be another application that you can improve the machine learning. This deep learning is inspired in this pattern of information processing of the human brain. Next slide, please. Then moving to the digital transformation that we see at Bayer, it's important to highlight that these digital tools, including AI, they have been the propellers so that we can keep ourselves firm in our purpose to provide a better life and a vision of health for all, leaving no one out. In the area of human health, next slide, okay, we believe that artificial intelligence is able to improve the daily routine of patients, doctors, and society as a whole. Why is that? we believe that we will be able to offer the appropriate treatment, the correct treatment for the correct um, patients in a timely way. We have been using the artificial intelligence to identify new potential drugs and also new potential targets and biomarkers for the diagnosis, also in clinical development. And we also believe in the power of collaboration to propel the use of artificial intelligence. So Bayer has signed an agreement with this company in the UK, Essentia, to be able to work in the search of new candidates for cardiovascular and oncology drugs. And also I can mention the creation of live hubs in our organization. These will be incubators for solutions where we provide mentoring, partnerships, alliances with startups, mainly in the artificial intelligence field. And I would like to cite the UK hub. The UK hub was inaugurated last year and it has been dedicated to solutions in artificial intelligence in health. Next slide. In agriculture, we can also think or compare how the smartphones, they have been a revolution in personal communication, right? And today we see sensors, drones, satellite images, all of them working in order to provide this huge transformation in the field. And behind all of that is the digital science. We have the machine learning, we have deep learning. All of that is the basis for the tools that we are developing. Next slide, please. One of the solutions or one of the companies in our group that provides several digital solutions in agriculture is Climate Corporations. And through the solutions offered by Climate, we provide a training on the applications, on the apps that they can recognize and identify the typical problems in the field, creating alerts so that the agriculturists, they can take action and they can protect the productivity in their field. Also in disease diagnosis for the crops. Can you imagine when you upload a picture in Facebook or Instagram and the application immediately identifies or recognizes some of your friends or relatives and will then pin that image. In the case of a crop, we can identify a lesion by the color, by the extension, and provide the appropriate diagnosis. And in the field also, we are changing how we offer and develop our products in our portfolio, like the seeds, for instance. For that, I'd like to share with you a short video, 2 minutes. I'm sorry, it is in English, but it's really, it can illustrate this transformation. The next slide is a video. Thank you. Now, going into the precise topic of our panel. Next slide, one more. As Wagner has already anticipated, we have several applications, patents being granted, and where the technical solution or the inventor was assisted by artificial intelligence. And now we see the first international publication where artificial intelligence was assigned or nominated as the inventor, which is the Davis case. According to the representatives in this case, Davis has received generic training. It did not receive instructions to solve a specific problem. And at a certain point, it is started to develop inventions that they call independent, autonomous inventions supposedly without an intervention or a human control. And this is the point that generates the complexity in this situation. Because if we were thinking about the inventions where the inventors, they are assisted by AI, maybe we would not see much difference from those that were implemented with a computer. But in this case, that's not it. And here we have more controversies here, because some specialists, they state that we are not at a point that the artificial intelligence can be considered as existing without intervention of human control. It could maybe act without the supervision. But anyway, this was the argumentation that the representatives brought to us. Okay, this WO was analyzed by the WIPO and they were edited. The EPO based itself in a systematic analysis in the patent convention, and to state that due to the set of terms used, we had an indication that only natural persons, individuals, could be the inventors. And they had a comparative study stating that in other countries, the same conclusion would be reached. There is an appeal going on now, pending, and this case has been analyzed in the United States and has been rejected as well. Next slide, please. I don't intend to bring a position regarding this issue, because I believe that we're still collecting data and contributions. We have seen OMPI providing or performing consultation, calling members of the civil society to contribute, some patent officers, the SPTO and others, the EPO also ordered some studies last year on the topic. So I'm bringing to you some topics for us to discuss, maybe drinking some wine and expanding our minds, because really this situation needs a more sophisticated analysis. The first point I see here is, indeed, there is not such thing in the Brazilian national legislation, and I dare to say not even in the other international legislation, a express bar, as there is no express permission to nominate artificial intelligence as an inventor. So my first question would be, if we deny this invention patent, conceived as in the Davis case, Davis was assigned as the inventor. If this invention satisfied the patentability requirements in TRIPS, would that be a violation of the international treaty? This is my first point for consideration. Here in the Brazilian law, the fact of being acknowledged as the inventor, this is a personal right and is a link to a natural person, an individual. So I ask to you, wouldn't it be a right, a moral right, to know the true author, since it is an invention that was autonomously developed by an artificial intelligence, and recognize, wouldn't we be only recognizing that, or should we need to go a bit further and create a personality, a legal personality of fiction that would be electronic for this artificial intelligence, so that it would have rights and obligations, duties? So to move a little bit further on that, do we have legislation to guarantee the inventor the pay for that, to be awarded for that? So how would it be if the inventor is an artificial intelligence without this solution? Regarding the ownership, the property, it is related also to the inventor issues, because the EPO regarding Davis, the patent application was required by the developer of the artificial intelligence, which is the proprietary. And the EPO said or argued that you cannot transfer that invention to the applicant, because Davis, through a work contract, because Davis was not a person, and also you could not transfer the ownership because Davis is a machine and would not have right for property to own something, to transfer that to third parties. But let's think about the result. What about if this result was not inventive? We would be led to think that result, that product that was developed by a computer, would belong, at first, at least, to the owner of the system, of the machine. So, but we have a different view because it is an inventive result. Is that it? So this is another topic for more reasoning here. And finally, the last point, the EPO ordered a study where it would analyze two situations. One, where you would acknowledge the artificial intelligence as the inventor, and in this case, you would need a change or reform in the legal system that would be more robust to accommodate this change. And in the other case, you maintain the status quo for the inventors. And in this case, they say that the right to the invention, maybe you would have to combine or to think about the creative contributions of the owner, of the system, the developer, the user, so that you would have a fair system. In other words, next slide, please.
Well, very rapidly now, talking about claims, I chose to talk about inventive activities because the topic was quite extensive. And the controversial issue is the technician, the expert. Who would that be? Let's assume artificial intelligence became usual in a certain technical area. Who would be the technician, the expert in the area? Would that be easy for me to assess the technical knowledge of this individual? Would there be any increase in this level of inventive activity? What is the comparison? Talking about the Davis invention, Could we think about a machine as an expert technician in the area? Some authors are doing predictions and forecasts for the future, talking about persons with ordinary skills in the art becoming machine with ordinary skill. This is something that might happen in the future. Now, some considerations about the future. I think we should not just give in to the fear of a dystopic future, as we have seen in some TV series, as Black Mirror. And there might be a positive step of social economic development where artificial intelligence might be working for the benefit of humanity and with humankind. This is a reality. We have seen that based on the high number of applications filed. And perhaps we will need new understandings and interpretation of the existing legislation. Or perhaps we might need to change some of the current standards and legislations so as not to compromise the very dynamics of the intellectual property system. So I would like to thank you all, and I'm available to answer your questions. Thank you. Thank you very much, Edson. Excellent presentation. The topics are truly so appealing and interesting. They would need a more philosophical discussion over a glass of wine, perhaps, as you said so well. In my presentation, I also mentioned one of the first dystopic movies, 2001, where Hall revealed himself. But we have other not so dystopic films like Her, where Joaquin Phoenix became famous. The issue of intellectual property and AI is a new topic. I said that before. It was studied by ABPI regarding copyrights, and this year regarding patent rights. This was mentioned by different people. And in the next presentation, we will also have that. I will now introduce her, the next speaker, Dr. Barbara Fiacco. It's an honor to have you here with us. She is a partner of Foley Hall, and in the office, she's a co-chair in the Department for Litigation and Patents. She's representing clients in very complex cases, especially in the biomedical area. Monoclonal antibodies, recombinant small molecules are the main areas. Also, defending companies regarding life sciences, regarding patent infractions and violations, but also contracts and other litigations, normal market litigations. She was recently nominated the president of ALPLA, our partner entity in the US. So I give you the floor, Barbara.
Thank you, Claudio. And thank you both Wagner and Edson for your excellent presentations. I can't promise a glass of wine, but I think that my presentation will probably move into some of the more philosophical topics that Edson teed up for the day. And I'll do so with US law as a starting point. So I'm going to move ahead, I think, because you probably all know a little bit about some of the early slides that I had teed up, and we are a little short on time. So let's start out talking about U.S. patent law. You heard earlier that there's this sense around the world that an inventor has a moral right to his or her invention. That is not exactly the case in the United States. I think U.S. patent law is set up a little bit differently. And the idea behind it is, it certainly is very focused on the human inventor. You know, in the 18th century, there were only human inventors. But the law is very much set up with the assumption that human beings need to be incentivized to invent, that they may not just do so without any incentives in place. So our patent law is set up so that in exchange for disclosing someone's invention, that person is entitled to a monopoly of 20 years from the date of filing. So very much embedded in the concept of patent law is that there are incentives needed to get people to innovate. And then based on the disclosures that are made, others can build on those disclosures, leading to further innovation. There came a point in time when it became clear that inventions were being made not only by individual inventors, but by groups, by teams working together in companies, in universities. And there became a concern that that our incentive system would break down if individual inventors thought that they were only in it for themselves, that a member of the team may run out to patent some aspect of the teamwork and then create prior art that would prevent the ultimate invention made by the team perhaps from being invented, or just would otherwise pit people against each other. So one of the things that has evolved in our patent law is this concept of joint inventions. And this is going to become important as we think about the next step, as we move into inventions that involve AI, but may not be entirely the AI generated invention. So in US patent law, there's this concept that joint inventors can work together in a collaboration as long as they work towards the same end to solve a problem. They don't necessarily need to work together. They certainly don't need to be from the same field of technology, and they don't need to make the same amount or type of contribution. They just need to make some inventive contribution to the patent. And very interestingly, not all joint inventors need to have actually been involved in conception, in final conception of the invention. If you think about inventions as a relay race on a track field, and there are 4 members of the team and they each run a lap and they pass the baton to each other, only the runner carrying the baton around the final lap needs to have completed conception of the invention, which is very interesting because we very much think about inventions as a mental act, as a conception. And that has been true. That's how we think about inventors in the United States. And ultimately, conception is when the invention becomes defined as something that can be patented. We have a lot of cases that say conception is the touchstone of invention, and it's the formation in the mind of the inventor of the complete idea. It has to be definite and permanent. We also have case law, and you've heard about this already. We've had existing case law on the books for a long time that says people make inventions, not companies. So legal entities, and logically by extension, AI entities cannot conceive of an invention, so they can't be named as inventors. That question was really finalized when the USPTO rejected the Davis application in April of this year. They very clearly said as we have already heard, that in order to be an inventor, the inventor must be a natural person. You've also heard already from my panelists that the EPO has similarly rejected the Davis application. Along the same lines, that the inventor has to be a natural person, and including that that rights, essentially, so this takes on a little bit of the moral rights component. There have to be rights that that inventor can have that can be passed on and assigned to a company or a legal entity. The UK IPO has done the same with similar rationale. And we know in other jurisdictions, Japan, China, and Korea, there are laws that prevent AI entities from being inventors. But I want to step back for a minute and have a conversation about whether that's right, ultimately. When we think about what's coming next, which we may not even be able to imagine in our heads, right? Innovation is moving so quickly. How is it that we as lawyers can make sure that the law is not preventing further innovation or disincentivizing further innovation? So if we think about in the AI context, who could possibly be an inventor? Who or what? We obviously think about the programmer who's potentially focused on the algorithm. In certain circumstances, perhaps like those described by Edson, you may have a researcher who could be a chemist or a molecular biologist or both of them, who are figuring out how to model what small molecules may best bind to a particular protein or a biomarker in order to treat a disease. And if that could be done first through computer modeling, including potentially the better design of a small molecule entity, then research and development could move forward by leaps and bounds in the therapeutics context. Even going so far potentially as modeling, which subpopulation of patients may be best served by a particular small molecule or antibody. Which could certainly streamline clinical trials. There's also data providers who could potentially be joint inventors. There may be a different researcher who's reviewing the outcome of what comes out of the computer modeling experience or experiments. And then also the AI entity itself is another entity that we need to consider, particularly in the context, I think, of that gray area where we're not operating with a fully human team of joint inventors, and we're also not operating in the context of really what Davis wanted to consider itself, or what Stephen Thaler wanted to consider Davis, which was an AI entity operating on its own. I really believe that the next step that we're going to have to tackle is what happens when there's some combination of human and AI contributions that come together. And in some ways you could say, well, that's not a big deal. We can, under the existing law, we can just name the human beings who are part of the inventive team. And that may work in some jurisdictions. One thing that I do want to alert you to, though, is that I can imagine an easy hypothetical in the United States where there is one human inventor named, and that human inventor was assisted by AI. If that patent is an important patent and it's blocking a competitor from entering a lucrative market, there is no doubt in my mind that someone will challenge that patent and say that the human being who was named an inventor is not actually an inventor, did not make significant inventive contributions under existing US law. Only the AI entity perhaps made those contributions, and therefore the patent is invalid and the invention is available for all of the public to practice. I think there are, if we go back to incentives, there are incentives under the US system to make that challenge in order to invalidate patents. And so that's something that we're just going to want to be particularly aware of going forward. I think, going to the question that's on the horizon that Edson posed at the end of his presentation, what do we is the human inventor requirement a relic of the past, or is it an important policy-driven judgment that we need to maintain going forward? And it comes down to the question, if you think about it in the context of US law, as I've described it, do we need incentives for purely AI-created inventions to occur, or will they occur automatically? Are the AI entities different from, in some ways, human beings, or is the investment behind those AI entities, at least for some period of time, going to be needed in order to push the invention and the innovation forward? We also need to consider the question of whether, in the context of AI, where data, the underlying data to train the AI is so important that we risk, if we provide broad patent protection to AI-created inventions, do we risk aggregating AI-created inventions with a smaller group of companies, a smaller group of large companies, the ones that are big and have access and are already accumulating all kinds of data about you and me and patients in the medical context, even if it is done in accordance with our privacy laws. There is a huge amount of value in data. It is being created. It is being analyzed and stored. And there is a risk, I think, that there becomes this aggregation of haves and have-nots, and that's something that needs to be considered. The flip side is that we also, it is possible, if you think about the incentive framework that currently exists, that if AI-created inventions are encouraged, patenting of those inventions is encouraged, there are, as you've heard, disclosure requirements. Those disclosure requirements could potentially include a fair amount of disclosure about the underlying training data that's needed. And it may be that then makes that data more available to entities, the have-nots, right? And that we end up seeing a little bit more of an equalization and the ability for other entities to build on the data that's been disclosed as part of the written description, as we would call it in the United States. So another question that's been posed is really whether there's a middle ground here, and whether in certain circumstances, particularly for purely AI-created inventions, should we consider something that is perhaps patent protection that's a shorter term, maybe not 20 years from filing, maybe a heightened obviousness standard, given the role of the AI-created inventions and the difficulty of figuring out really who a person of skill in the art is, or the AI entity of skill in the art. So there seems to be some room there for at least some policy discussions over that glass of wine. The difficulty, again, is that what about the situations where the AI entity is actually part of the collaboration and is really perhaps making a contribution to a team effort, and how to manage that? So as everyone else has mentioned, there's a lot of overlap around inventorship and ownership, and whether we could find a way to recognize an AI entity as an inventor or owner, and what would that look like? When we think about what legal personhood means in the context of a company, companies in every jurisdiction have responsibilities, right? They have obligations to behave in certain ways under criminal law, under privacy law, under product liability law, and behind those stand individual people. So there's layers to the corporate law that have evolved over many, many years that have ensured accountability for those companies. And we would really need to think, I think, long and hard about what that would mean in the context of an AI entity. Who would need to stand behind that AI entity, and what would the obligations of that person or that company be? But if we step back from this for a moment,
Mas se nos afastarmos disso por momento,
I'll just leave you with the question of whether really,
eu vou deixar vocês,
in the short term, while we think about these inventorship issues, can we address
pensamos nessas questões
in the context of
da
contract.
invenção e da titularidade.
We see that a little bit already. You
Já
could use
estamos
license
vendo
agreements.
isso
You can use
pouco.
Joint development agreements in ways to work through, regardless of who the inventor may be, regardless of what the invention is, at the outset to have certainty. We could ensure through contract law who actually owns the IP generated by the AI. And so I'll leave that to you. They require some costs upfront in some of the unusual situations that may have involved form agreements in the past, like a service agreement or going outside of the scope of work to do troubleshooting. If you have a computer programming providing you software for your database, could create complications around potential inventive contributions that one might need to think through. But I think this could be done, and we could achieve a lot of certainty in the short term while we work through the bigger philosophical questions about inventorship. You know, I'm running out of time. My slides do include an update of a USPTO report that's come out recently, just about a week ago, with public comments collected on AI and IP policy. And then for those of you who are not involved in the AIPPI World Congress last week, a couple of interesting just takeaways from resolutions about inventorship of AI created inventions, as well as what protection the AIPPI Congress believed should be conferred upon databases. So if you weren't able to participate in that, those are policy issues that are sort of taking on the big topics for the future. And with that, thank you very much for your time. I want to thank my panelists. This has been a lot of fun, and I hope that next year there will be more in-person collaboration between AIPPI, AIPLA, AIPPI, and ABPI. So thank you, everyone. Stay safe and healthy. Sure, thank you. So the resolution that's still being finalized, but that was voted on at AIPPI last week on AI entities and inventorship did specifically state that an AI created invention should not be rendered patent ineligible simply because it was invented by an AI entity. So it leaves open the possibility that an invention like the Davis invention could be patent eligible, and actually suggests that it should be, which I think is a very interesting departure from at least certainly the policies of the United States, and leaves open something for the future. Obviously, ownership and a number of other issues would need to be worked out. And similarly, as you noted, Claudia, the discussion about the protection of data led to a resolution that essentially accepts the proposition and recommends that while mere data itself shouldn't be entitled to protection under intellectual property laws, that databases in which there is investment made should be subject to a sui generis, a new IP right that does not yet exist in jurisdictions anyway that I'm aware of, and that it is based on investment, and the owners of that database should be those that made those investments. I could imagine some conflicts as a litigator at the margins about how you would actually define that over time, but that it is an investment-based ownership right, and that third parties should not be allowed to, utilize that data without authorization. It also recognizes that it's a complex area, and we would need to work around issues like freedom of speech and expression, privacy law, and strike a balance between the IP rights and all of these other policy issues. But that in concept, there needs to be database protection and ownership.
Okay, moving back to Portuguese. The next question, Wagner, from Dr. and Mrs. Andrea. She asked right in the beginning, she asked about the examination guidelines. And she's asking if there are specific guidelines for this area in artificial intelligence. Well, thank you for the question. It's good to clarify this point. We believe that the guidelines that were published in 2016, well, the wording was not ideal, but at that time we had to communicate what we were doing. We had been working on that for a while at that time, and we didn't have the resolution published yet. So we needed that text to solve the conflicts in logic and procedure. So we have dedicated ourselves more to that aspect, and we decided not to delay more or further to publish a guideline on air. But so we had to publish that review guideline, and next year we will have a deeper study and have some case studies as well, some examples related to artificial intelligence, and also related to data. We have to go deeper in this aspect, and we intend to include that in the guideline. Okay? Thank you. Excellent. Very good to hear that. And also, I would like to acknowledge some contributions that we had, some comments in the chat. Our friend Rafael Atabi and Lelo as well. Rafael mentioned the APPI, and Rafael about the Canadian CIPO. And the question that was placed by William, it's a provocation. If the assessment of the requirements of an invention created by artificial intelligence, they could be examined by an artificial intelligence system. So I'm teasing you here, but and I give the floor to you. So are we going to have AI examinations in our institute? Well, this is a question that I raised during my presentation, the change and the person having ordinary skill in the art to a machine having ordinary skill in the art. So how this transformation is going to happen and when, it's very difficult to pinpoint, especially when, because I do believe that we are not at that point of sophistication yet. Until then, I do hope that we gather a lot of baggage, conversation, consultation with society in general, so that we can finally reach a satisfactory standard that would be appropriate to this intellectual property production system. Regarding this topic and moving a little bit towards a different area, I'm really not comfortable if we have a bar to assign an AI inventor. I'm not advocating for that, okay? But what I'm saying is, should people omit this piece of information, so they will hide this information so that it will prevent the rejection, or should they maintain that confidential? So then you will not have the disclosure to the society. So it really makes me uncomfortable, this issue. All of us, I think, we all are uncomfortable, I would say, with that. Barbara, Edson, Wagner, I really would like to thank you all so much for your presentation. I have other questions, but I have been told that Barbara really needs to end at 12:30 sharp. And I really thank you for being so punctual and sticking to your times. And we had some other questions, as Edson said. We could spend hours and hours discussing here these topics, and it can be a provocation to ABPI to create this study group and go deeper in this topic. So really, I thank you again to all of you and to all the participants. I'd like to close our panel. Thank you all very much and good afternoon.
Já faz algum tempo que falamos da velocidade das transformações do mundo. Mas, na verdade, esperávamos que essas mudanças seguissem um ritmo imposto por nós mesmos, segundo nossas próprias necessidades. Como se as mudanças fossem previsíveis ou fáceis de assimilar. Até que o mundo parou e tivemos que ouvir as notícias e ver de frente a nossa própria vulnerabilidade. Nenhum de nós esperava experimentar uma situação como esta, mas aqui estamos, imersos nela. Mas será que conseguimos aprender alguma coisa com tudo isso? Ser capaz de aprender é a marca maior da nossa condição humana. Mas tivemos que nos superar para lidar com o que chegou. E agora ficou patente o que é verdadeiramente importante para nós. Entendemos que fazemos parte de um grande ecossistema e que cada um depende dos demais. O desafio é aprender juntos os novos caminhos da transformação digital. Fazer diferença com inovação, empatia e coragem. É com esse espírito que a equipe da LD Soft está aqui pronta para ajudar você a fazer cada vez mais pelo seu cliente, oferecendo meios para você trabalhar com mais produtividade e eficiência, mesmo nas condições inesperadas do trabalho totalmente remoto. Nossas ferramentas oferecem aquilo que você precisa para dar atenção a tudo que realmente importa e que só você pode fazer. Assim, ter tempo para oferecer ao seu cliente os resultados de excelência que ele sabe que vai receber de você. Por isso, vamos continuar firmes, para que em breve possamos destampar nossos sorrisos e comemorarmos as novas conquistas juntos nos desafios que estão por vir. LD Soft, potencializando o universo jurídico através da tecnologia.